Good morning, court. Today I rise before you as the appellee in the landmark case of Roe versus Wade, defending the rights of Jane Roe and the constitutional principles at the heart of this matter. This case is not just about abortion. It is about a fundamental question. What limits can the government place on personal autonomy? And to what extent can the state intervene in private medical decisions between a woman and her doctor? Let me begin with the core facts. At the time this case arose, Texas law criminalized abortion in almost all circumstances, allowing it only to save the life of the mother. Jane Roe, a pregnant, unmarried woman, challenged this law, arguing that it violated her constitutional right to privacy. And the district court agreed. And it is very important to concentrate on these circumstances. As an appellee, I urge this court to affirm that decision. The constitutional foundation of our argument rests primarily on the 14th Amendment, which protects the rights to liberty and guarantees due process of law. This right to liberty, as interpreted by the United States Supreme Court in earlier decisions such as Griswold, Connecticut, encompasses a right to privacy, especially in matters of family, marriage, and procreation. And let me be clear, we are not arguing that abortion should be unregulated. Rather, we are arguing that the state's interests must be balanced in this matter against a woman's fundamental rights. A complete ban, such as the one Texas enforced, fails that balance. And in the context of business law, think of the implications. Businesses operate under the framework of constitutional protections, including due process and privacy. If the government can intrude this deeply into private medical decisions, where does it stop? Could it later dictate how companies provide reproductive health care, how employees regulate women's bodies, or how insurers determine eligibility? These are not far-fetched hypothetical